I'm going to talk about 5 things that you should do if you've been charged with drink driving. Now, the first thing is to know the charge. And the charge will be on the charge sheet, and there's an example of the charge sheet here on the right hand side of the screen. Now then, this charge sheet has actually been handed to somebody when they've been in custody in a police station, but you might also have a postal charge. They really mean the same thing. It's a formal statement saying what you've got to go to court for. Now then, this charge sheet here is a charge of drink driving or driving with excess alcohol. But you might also have been charged with drunken charge, which is actually a less serious offence, or sometimes a charge of failing to provide. Once you know what the charge is, you know what you're facing at court, what the potential penalties might be, and also if you can defend the case. Now, the second thing to look at on the charge sheet is the reading. Now then, in this case, the reading was 98. It's a reading of 98 micrograms in 100 millilitres of breath. 98 in this one. Now, there are different readings depending on whether it's a case where the police have taken a breath test, a urine test, or a blood test. Now, all drink driving cases or driving with excess alcohol cases face a minimum disqualification of 12 months. Or 3 years if it's a second offence within a 10-year period, and then either an unlimited fine or up to 6 months in prison. Now, magistrates use sentencing guidelines to work out what the sentence is going to be, so you should know what those guidelines are before you make any decisions about what to do in your case. Now, these sentencing guidelines here are an extract, and these deal with cases where there's been a breath reading. There are different sentencing guidelines for blood and urine, and different ones again for somebody who's been convicted twice. Now, the way things work is that you look at the breath reading on the left-hand side here. The limit is 35, so these are the lowest cases. The lowest reading cases are 36 to 59, and they will start off with a band C fine. And in fact a range of a band B fine to a band C fine to a lower fine to a higher fine, plus a ban of 12 to 16 months. So that's for the least serious cases. For the most serious cases of 120 above, the magistrates will start out by looking at 12 weeks custody. They have a range of between a high-level community order to 26 weeks custody and a ban of 36 to 60 months. Now, these ranges are here in the middle, so the magistrates can adjust their sentence depending on any aggravating or mitigating features. So an example of an aggravating feature might be that there's been an accident. A mitigating feature might be that somebody's got a perfect record, they've never been in trouble before, and the case is going to have a really serious effect on them. So those are the kind of things that the magistrates will take into account. Now, we then move on to looking at any defences that you might have. Now, you need to watch out with this because unless you have a good defence or a strong defence, then it can get quite expensive to defend drink driving cases, and you can get yourself into all kinds of difficulties. I'm not going to go through all the potential defences, but some of the most common ones are I wasn't driving. Another one is called the hip flask defence. So a hip flask defence is a case where somebody's been breathalyzed after they've been driving, but they've had some alcohol between driving and being tested. And then there are all kinds of procedural challenges. So these are challenges to the way that the police have dealt with the case, the way that the sample has been tested, and anything else that might have been done wrong during the prosecution. So those are perhaps the most common ones. That's not all of the defences you could put forward, but once again, it might be a good idea to get some legal advice before you go ahead pleading not guilty and challenging the case in the magistrate's court. Now I'm going to come on to whether or not you should have a lawyer and what kind of lawyer you can have. Now, you've got a few different options, so I'll put those on the left-hand side of the screen. The first one is no lawyer. There's plenty of people go along to the magistrates' court and they don't have a lawyer, and they represent themselves. They put forward their own arguments in court. The second option is the duty solicitor. There's a duty solicitor at every magistrates' court, and they will help you out on the day of the hearing. So you can speak to them before the hearing takes place. You can't get an appointment with them in their office before the court hearing, but you'll speak to them before. They'll get some papers from the prosecutor and they'll discuss what's going to happen in court and represent you just at that first hearing. The third option is your own solicitor. Okay. Now, some people might be able to get legal aid with their own solicitor. Quite often drink driving is difficult to get legal aid because the cases don't meet the criteria that you need to meet to get legal aid, but it is possible sometimes to get legal aid. Otherwise you have to pay privately for your own solicitor. Now, I've been talking about a solicitor, but of course you could also have a direct access barrister. So a lawyer really means a solicitor or a barrister. Now, I mentioned back here that you don't have to have a lawyer. There are a few situations where it really is a good idea to get a lawyer involved. The first one is if you're going to plead not guilty and take the case to trial. Once again, you don't have to have a lawyer if you do that, but it's a good idea. Second case is if you're a custody risk. So those are in cases where it's a really high reading, or you've been in trouble before, or there's some kind of aggravating feature like a serious accident. And the third time you might want a lawyer is if you're not comfortable putting your own case forward in court. So if you're not comfortable speaking in public or expressing yourself in public, or you want somebody to go along with you to make sure that the procedures followed properly and everything is dealt with correctly, in that case you might want to organise a lawyer before the hearing. Now, the last thing is to prepare properly for court. So a lot of that's going back and looking at the things that we've talked about before. But the first thing is that you need to decide whether you're going to plead guilty or not guilty. If you're going to plead not guilty, then you need to decide what the trial issues are going to be, because you'll be expected to identify those at court, and you need to know what witnesses that you need. So if you've got any eyewitnesses that you want to take, or sometimes you'll need an expert witness, especially if you're going to try and challenge the case in a technical way. If you're going to plead guilty, you need to decide what your mitigation is going to be. So what kind of things you're going to say to try and persuade the magistrates to impose the lowest possible sentence. And you might also want to get some character references and letters. It shows that you've taken the case seriously, and quite often the information in a letter can help the magistrate sentence you. Then the second thing here is just practicalities. Make sure that it sounds silly, but make sure that you're not late. Make sure that you know where the court is. It's really important to get there on time, and it's really important to turn up smartly dressed and deal with the hearing properly. Now, I hope the information that I've given you has been useful. If it has, then please share this video with other people by clicking on the buttons at the bottom. I've also put some information in the links at the bottom to the sentencing guidelines and to some posts on my website which might provide you with a little bit more information.